So, friends, we are continuing our discussion and understanding Section 23 of the Indian Contract Act, which broadly emphasizes on the fact that certain agreements are considered void, which are not going to be enforceable simply because they are not in public interest, which we call as opposed to public policy. And in the previous, session, I was trying to deal with Competition Act 2002, trying to tell you the background of how the Indian Contract Act is complemented with several other special legislations that probably give us an idea of what is the direction of public policy in this country. Now, as I told you in the past, public policy is not defined in the Indian Contract Act, and it is left to judicial discretion to actually define public policy. It is a judiciary that will probably align the direction of public policy from time to time. And yes, probably it's not the sole proprietary jurisdiction of the judiciary. The legislature also has to play a very important role in laying down the direction of public policy, especially in contracts and agreements. And that's why you will notice that the legislature from time to time has provided several legislations that can give us an idea of which are these agreements that are not going to be enforceable, right? Now, if you look at the competition law, and something that is very important for our understanding, friends, is the concept of bid rigging. Now, we know that we are going to deal with tenders and public procurement at a later part of time in our course. And tendering and public procurement, you will notice, friends, is actually a huge business context or an opportunity in India. The government is rather a huge contributor to the economy in India, because the government is also not only doing governance in terms of providing amenities to the citizens, but you will notice that in India, the government is also doing a lot of businesses. So we have a lot of banks that are government banks, or what we call as public sector banks. Then we have public sector companies. And don't forget, these public sector companies, as I told you in the past, are not only central government, but they're also state government. Now, one of the mechanisms that government agencies must contract is the rule of tendering. Right? They have to follow by tender. They have to go by competitive quotations, because what does tender do? It actually lays down a transparent process of contracting. So tendering is the rule, and there can be exceptions, but we'll come to that a little while later. Now, bid rigging. Now, tender calls for bids, and they are contractors who have to submit their bids. The government will evaluate those bids, and the government will actually give the contract to the most favorable bidder, right? So you will notice that we have the concept of L1 and H1. L1 means lowest bidder number one. He has quoted the lowest price. Now, this lowest price is where the government is buying. They go by the lowest price mechanism. If the government is selling, they go by the highest price mechanism, which is called the H1. Now, in either of this context, what may happen, friends, is please note, this was something that even the MRTP Act had to deal with, but they could not deal because the law did not provide specifically for it. We know that this is a prevailing condition where contractors actually enter into some kind of a collusive, secret understanding or an arrangement or an agreement. So, bidders and contractors can actually rig a tender. Rigging of a tender means it is trying to defeat the purpose of tendering. See, the purpose of tendering is to actually ensure competition, right? Better competition means better price. Better competition means better product, right? So competition actually is healthy to the market conditions. It is healthy to consumer interest. It is healthy to even government interest. Right? Now, can bidders rig the tender so as to defeat competition? Can they disclose their price information or financial information? Can they divide the markets among themselves? Can bidders create entry barriers for new contractors to come in? So I think these are some of the strategic behavior among contractors, which I think the law has very clearly now said is not going to be permissible. So any kind of agreement that tries to defeat the purpose of tender amongst the bidders, right, where we say, yes, we think that this agreement is resulting in bid rigging, is prohibited under the competition law. Now, this is very important. This is important because whenever the government goes by any kind of a tender or even if it could be a private kind of a contract, the manufacturers, the producers, the distributors cannot enter into any kind of secret understanding so as to defeat the purpose of competition, so as to defeat the purpose of tendering. In case they try to do that, which see you see the law very interestingly. It says any person trying to manipulate the process of bidding, or what you have done as a secret arrangement or an agreement is adversely affecting competition, then in those circumstances your arrangements, your agreements, any kind of understanding among the bidders is something that the competition law prohibits. Right now, I believe that when we read section 23 of the Indian Contract Act, to understand what public policy is, the competition law is a great reference, right? Which clearly says these are agreements opposed to public policy, right? And I think the competition law lays down those kinds of ideas of what kind of agreements are permissible and what are not permissible. Do not forget the fact that the competition law is a special law, right? And under the Competition Act, we have established the Competition Commission of India. This is a very interesting body. It is not only what we call as the regulator in the field of competition, but it is also the adjudicator in the field of competition. So the Competition Commission of India can be complained to for any kind of anti-competitive agreement activity that has come to the knowledge of any individual or any businessman. The Competition Commission of India will investigate that complaint. They will find out whether there is any truth in the complaint. And once they finish their investigation, they will inquire. And once they will inquire, please note under the competition law, there are various kinds of penalties that can be imposed on parties who actually engage in anti-competitive behavior or have entered into anti-competitive agreements. Please note, it is not only the business of the Competition Commission of India to impose penalty, it is the business of the Competition Commission of India to also hold these agreements as being void. Now, please refer to section 3.2, which says that anything that is in contravention of section 3.1 shall be void. That means agreements will have no enforceability, and hence, whatever has been decided by the competition law, a regular court is not going to give you any kind of remedy. It will not hold the agreement to be enforceable at law. Now, that I think is a very, very important and a significant aspect of public policy in India. So, I think business leaders, business managers, entrepreneurs must know what agreements are permissible and what agreements are not permissible. For example, friends, when you look at the competition law, as I told you, there could be an exclusive supply agreement. Now, exclusive supply agreement very clearly says that someone who is to supply me goods will only supply goods to me and nobody else. Now, please note, not all of these kinds of agreements are going to be illegal or going to be void. No. You can still have an exclusive supply agreement. The point is, what is the purpose, intention, and motive of this agreement will be the first criteria to intervene under the competition law. The second intervention would be, what is the impact of this agreement on the competitive market? This will be the test. So please note, under the competition law, we have an interesting idea which says that, look, agreements will be tested. So it's not that every agreement is going to be declared to be void. Every agreement will be tested in terms of what kind of effect it has on markets and competition. So the rule is what we call as the rule of reason. You will have to reason out the impact of this agreement, and in case the agreement has an adverse impact on competition, only then the agreement shall be held to be void. Right? So it is the rule of reason. Now, against the rule of reason, you have another very interesting rule called the rule of per se illegal under the competition law. Now, the per se illegal rule applies to agreements such as, please note it down, cartels. Interestingly, friends, the term cartel has been existing in business and in markets for a long period of time. Cartels have advantages. Now, the oldest cartel, friends, is among the oil producing nations called OPEC. Now, Please note, they are sovereign nations. They're not business entrepreneurs. So sovereign nations can have cartels. Maybe that is not the purpose of any competition law. Competition law deals with entities inside a country. They're not about what sovereign nations can do. So opaque is just an example of cartel. It's not something that a competition law can actually deal with. But cartel is about those kinds of arrangements of manufacturers, producers, or association of manufacturers who also come together. Now, the purpose of cartel or cartelization, as we call it, is to see that the producers of one commodity or one services pool in together. They come together. Now, coming together is not a problem, friends. But once you come together and you try to rig the market, how do you rig the market? Maybe you rig the price. Now, how do you rig the price? Maybe you create artificial shortfall. You create artificial demand because you reduce the supply, right? So you can maintain some kind of stability of price. Now, cartel is illegal in India, like in most other jurisdictions, because it's not about let us try and reason out why you created a cartel, right? So cartel comes under the per se illegal rule. Any kind of an agreement that creates or attempts to create a cartel will be considered as illegal under the competition law. So agreements that create cartel have been declared to be illegal, and that's why I said that look, under section 23, while we debate about void agreements, we have to say that all void agreements are not necessarily illegal. Yeah. So illegal agreements are definitely void. So cartel is illegal and void. So once it's illegal, there is no question of it being enforceable at law, right? So I think the competition law again helps us understand an idea of what an illegal agreement can be, right? And please note, you will find cartels among a lot of these entities. In India as well, we have had some very interesting interventions of the Competition Commission of India. And the most famous case of cartelization was a case of cement industries or cement producers or manufacturers of India. It's an interesting case, a case that was filed by, please note, by the Builders Association. Yes, the Builders Association, which is also an entity of service providers, found that the cement manufacturers had entered into a cartel through their cement manufacturing association. And the Competition Commission of India did find evidence of cartelization. They did intervene. They did impose a penalty on the cement manufacturers. So these are issues that have been coming across in the Indian continent, in the Indian jurisdiction. And I think to a larger extent, the cement manufacturers cartelization case was an eye-opener. It was an eye-opener saying that, look, you can be a member of your producers or manufacturers association. These associations can do good work, but they cannot form a cartel. They cannot rig the price. They cannot create artificial demand and supply gaps. They cannot try and rig market conditions. They cannot create conditions that will adversely affect consumer interest, but most importantly, defeat the purpose of competition in the market. So more competitors, they must compete, right? That's the rule. If you actually do not compete, I think that is against public policy, right? Competition is very, very important for consumer interest, for national interest, and anything that defeats that kind of a purpose should be held to be against public policy. Moving forward, friends, I think just briefly, because please note, I think if many of us are interested in understanding competition law, I think a course on competition can also be very useful. But here we are just trying to understand contracts and competition and probably its application to tendering and public procurement. One other provision of the competition law for our reference at this point of time is Section 4. Friends, Section 4 of the competition law very clearly talks about abuse of dominant position. It says if anybody tries to abuse their respective dominant position, then to that extent, that is a prohibited, restricted activity. And please note, abuse of dominant position can happen also through a contract, through an agreement, right? So the point is, please note, friends, being a dominant position is not a problem for the competition law, for public policy. You can be a dominant player. You can have dominant positions in the market, right? Usually in the market, there is something called the market leader. right? Take the telecom space right now, the aviation space. We have Indigo Airlines as the market leader. We may have Airtel as the market leader in the telecom space. So they may be in a dominant position. Now, dominant position is not necessarily 50% or more market share. It can be 30%. It can be 20% as well. You are dominant. And please note, it's not dominant vis-a-vis the Indian market. It can be dominant vis-a-vis Karnataka or Bangalore or any other jurisdiction. So the market has to be defined to determine who the dominant player is. Right? It can vary from market to market. The point is, being a dominant player or being in a dominant position, and please note, dominant positions can arrive based on mergers. Right? Two competitors try to merge themselves, and from that merger, you can actually become a dominant player, or two companies can amalgamate together as well. This is called the combinations of competitors. So under the competition law, you have a combination regulation as well that deals with this practice. And please note, today, if you have to amalgamate or merger two companies which may have an adverse effect on competition law, the combination regulation says that you have to take the prior permission of the Competition Commission of India. So the Competition Commission of India can certify and say, okay, now if you want to merge these two companies, fine, we have studied it. They may not have adverse impact on the market and competition, and hence there is this kind of a preemptory intervention of the Competition Commission of India for mergers and amalgamations, right? But having said that, look, dominant position is fine. Abusing the dominant position is not fine. Right? So abuse of dominant position is a restricted, regulated activity under the competition law. And you could probably abuse dominant position by many such factors. For example, one of the factors is, looking at predatory pricing of goods and commodities. The other factor would be imposing unreasonable conditions on purchase of goods and services. Right? Imposing conditions is usually through contracts. Limiting or restricting the supply of goods and services, indulging in practices that deny market access. So, if you see, there are various aspects about how a dominant position can be abused, and you will notice that Section 4 very clearly speaks about all those kinds of activities that are important for the intervention of public policy. Now, the most famous case, friends, under abuse of dominant position is the case of the real estate sector. Now, the real estate sector, led by companies like DLF, were actually pulled up by the Competition Commission of India. Now, the real estate sector, friends, even now as we speak, and plus in the last 25 years, is a booming sector because there is a great demand for housing. Where are these demands coming from? They're coming from our cities, because a lot of the rural community is moving to the cities. They're getting into the service sector. They're getting into the cities, and hence the demand for housing has been increasing exponentially in the last 25 years. We have new companies coming into the sector. There is a lot of demand and supply gap. We have seen companies making a lot of profits, but at the same time, once the sector is new, right? Once the sector has a lot of demand, interestingly, naturally, there are companies that get into dominant positions. And DLF happened to be a dominant player in the Delhi NCR region. They entered into a lot of controversy because of the kind of relationship they had with the politicians as well, with state governments as well. And usually, once there is a nexus between the politicians and the contractors and the real estate builders, of course, the market conditions are going to be exploitative. And interestingly, DLF, in their contracts, especially when they were actually making buildings and selling it to allottees or consumers, they had unreasonable terms and conditions, including a term and condition where they said, we will not give a refund, right, if there is cancellation of booking. So DLF had some very, very extraordinary contractual terms and conditions, which the courts even found shocking. They said this is unconscionable. It's definitely not in favor of public policy, where, please note, the real estate companies, what we call in contract, have what is the clause called as reservation of rights clause. Now, what is a reservation of rights clause, friends? In reservation of rights clause, friends, you will notice that most of these real estate companies, what do? They have the right to make the agreement and the contract, right? So what does a consumer do? I'm sure some of you have experience. You might have gone to a real estate builder, you want to buy a flat. Look, the entire contract has already been drafted by the real estate company, right? You have to simply sign. Will they negotiate? Will they bargain? Will they change the terms and conditions? Look, they may negotiate the price. You may probably bargain the price, saying that floor price, you reduce it, give me some discount, give me some concession here and there. That is negotiable. But the substantive clauses in the contract is already something that is drafted by DLF. Then a consumer has no choice. He simply has to agree to it. Now, look, you can make a fair contract, but would real estate company want to practice fairness? How many market players actually practice fairness through their contracts and agreements? Very few. And I think that kind of attitudinal shift is something that the competition law and the contract law attempts to make, and that is what a legal system must have. You don't always need law to actually tell you what to do and what not to do. I think contracts must attempt fairness. If they do not, I think we'll have a regulator in each of these sectors to actually ensure that a fairness of contract, fairness of market, fairness of bargain is maintained. And that's why you will notice, because of these, what I would call as notorious builders. Now, please note, DLF was not only the one notorious in that. I'm sure many of you have read about Supertech, the problems of Supertech. Right now, as I speak, the courts have looked at making a demolition order for Supertech. We have seen groups like Amarapali and others which have actually tried to rig the real estate market, get into abusive behaviors, especially abusive not in the physical sense, but abusive in trying to use their dominant position to the adverse interest of consumers, adverse interest of the nation, adverse interest of public policy as well. Now, in the DLF case, what is interesting, friends, is the courts intervened. And how did they intervene? In a very unique fashion. What they did was they listed out the objectionable clauses in the agreement. Yes, they did so. They listed it out. They said these are the objectionable clauses, and they also suggested how in the future these clauses must look like. Right? That is something that I really appreciate how the courts did in this matter, because I think the duty of the court is not to say that, okay, the agreement is entirely void. Need not be. We can apply the doctrine of severability and just pick up those objectionable clauses in the contract and probably moderate it if it is possible. You can probably refine it if it's possible. So, interestingly, friends, you will notice that under the Specific Relief Act of 1963, right, as I told you, one of the remedial law that applies to Indian Contract Act is the Specific Relief Act of 1963. Now, interestingly, if you look at the remedies, now, most often they're not the most highlighted remedy is the remedy on damages. Suppose there is a breach of contract, there is damages, right? The second most, maybe, many of you may know, is what is known as the specific performance of a contract. Remember, we are going to deal with each of these a little later. But the point is, the Specific Relief Act also has something called rectification of an instrument. Yes, you're absolutely right in trying to understand what this means in the DLF case as well. The courts can rectify an instrument if they feel that it is rectifiable, and once it is rectified, the obligations between the parties can continue. So it's not that the instrument must be cancelled, thrown into the dustbin, held always to be void. It is not that only damages is the end result. The parties can continue with their obligations as well. Look, the allotee can continue living in DLF. The DLF can actually improve their attitude and services towards the allotee, and both can coexist. And the contract can still be enforceable at law, provided the court feels, yes, look, the objectionable clauses can be rectified in such a manner, and both the parties can continue to have a subsisting contractual and commercial relationship going forward. Right? So these are also the remedies that are possible. Now, for example, in government contracts, friends, once we go to arbitration, it's like, A won and B lost. I don't see why in contracts only that kind of a conclusion should be there. I think it's possible that courts can rectify, arbitrators can rectify the instrument and make the contract a workable contract. And that is something that probably the DLF case clearly highlights. So I've just given you two or three examples, friends, about how competition law becomes a very, very important legislation in understanding the parameters of public policy in contracts. Though the competition law application is far wider and broader, we have the Competition Commission of India being the market watchdog for ensuring fair competition in different sectors. But again, you will notice that the Competition Commission of India is the general competition regulator, whereas we have specific competition regulators in each of the sectors, like IRDA in the insurance sector, the telecom regulator in the telecom sector, the Reserve Bank of India maybe in the banking sector, right? So that's the kind of landscape that we have, and anti-competition is definitely against public policy, and hence today, if you go to the courts, I think the courts will not only apply the provisions of competition law, they may want to also refer to section 23 in saying broadly, I think this is what public policy actually means. Friends, moving forward to the second aspect of understanding section 23, or the dimensions of section 23, another interesting example that one can get is through kind of a practice, technology, science, and innovation in the medical sector, which is called surrogacy. Now, we know, friends, that there have been a lot of inventions in trying to help couples get a child. We know that the concept of a test tube baby was tested. Adoption is another kind of a practice that people can definitely get into. But surrogacy, or what we call as the fertility clinics, or IVF, in vitro fertilization, have been of a recent origin. Not so recent, but we already have a couple of decades of this practice already in place. The Western world, has regulations on surrogacy. India struggled to get a regulation. We have been struggling for more than a decade right now. Initially, it was called the ART Bill, Assisted Reproductive Technologies Bill. Two bills were actually debated. They couldn't be enacted. But only last year, in 2021, the Parliament of India passed the Surrogacy Act of 2021. Now, interestingly, friends, the concept of a surrogacy is something that one will have to understand, because, interestingly, there is an agreement for surrogacy. So, the basic relationship that governs this kind of a process is a commercial contract, though commercial surrogacy is not allowed, right? Now, interestingly, surrogacy, though there is no commercial about it, the document, is it some kind of an enforceable contract, right? So I think one will have to appreciate the enforceability through surrogacy, because the subject matter of surrogacy is a baby, is a child to be born and handed over to the couples. So what happens in surrogacy, friends? In surrogacy, friends, a kind of an intending parent who are unable to have a child go to a clinic, a medical hospital, and they express their desire to have a child. Now, it's this hospital or the clinic that actually identifies a mother, or a surrogate mother, or a lady who will actually agree to be a surrogate. Interestingly, this is called of a renting of a womb at times. It has several other names that are given. And in India, you will notice that a lot of foreign couples would come to India on what we call as fertility tourism. Why to India? Because it's easier and cheaper. Maybe, who probably agrees to be a surrogate mother, those from the economically weaker section of the society, they expect some compensation, they expect some payment, and hence they agree to bear fetus in their womb for 9 months and hand it over to the intending parents as well. Have there been challenges to this kind of an arrangement, agreement, or a contract in surrogacy in India? There have been several such challenges. One of the most famous challenges that one would want to look at is called the Baby M case, or Manji's case. It is the Japanese couples case. It's a very interesting case where a couple from Japan come to India for surrogacy. They constitute the surrogacy. They make the payment. The fetus starts developing in the womb of the mother. The child is born in India, But the couple that went back to Japan because they couldn't stay back for a longer duration of time, there was nothing called a surrogacy visa at that point of time. They decided to go separate. So nobody came to take the child, right? Now, in the Japanese couple's case, what happened was a newspaper report said that look, India is becoming baby market. What does that mean? It means that babies are being born and there are no parents to actually take care of the baby. Then there was this very interesting challenge. If you're born in India to a Japanese parents, do you get Indian citizenship? Right? Just because you're born in India. You will notice that the Citizenship Act has also been amended. It says that just because you're born in India, you cannot be a citizen. Right? One of your parents also has to be an Indian. So these are legislations that probably changed due to this very interesting concept of surrogacy or surrogacy procedures that were developed in India. Then you will notice that in that baby Manji's case, which is called the Japanese couple's case, the grandmother actually came and took the child from India. That's one of those cases as well. Then you have this German twins case. That is also a very interesting case where twins were born to a German couple, and that point of time Germany did not permit surrogacy. They did not legalize it. But he came to India. He decided to have a child. Then he got twins. Then instead of writing his wife's name in the birth certificate that went to the Anand municipality, he writes the surrogate mother's name so that he can get the birth certificate, thereby get the passports ready, then get the visa and take the children back to Germany. So that was also a very interesting case decided by the Gujarat High Court. So they're having issues and challenges of surrogacy. But the most important one for our reference is a case from the United States. This is a very interesting case about the challenges to the surrogacy agreement itself. Can an agreement of surrogacy be enforceable at law? Was the question that was posed in the American case called the Baby M case. So we had a Baby M case in India and we had a Baby M case in the United States. This was in the early 1990s and 1980s when, so there are two forms of surrogacy, friends. One is called traditional surrogacy, one is called the modern form of surrogacy. And, during those early days, I think, the practice of traditional surrogacy also was prevalent. And this case, there was an agreement that was entered into. And you will notice that this is a case of what we call as the Stearns versus Whitehead case. Okay. And Whitehead happened to be the surrogate mother. And the Stearns, Mr. and Mrs. Stearns, wanted the child. And they entered into an agreement thinking that they have hired the services of Mrs. Whitehead. Of course, you hire the services, isn't it? Now, the most interesting part is when you hire the services of a person, what it could be for. It could be to help you domestically. It could be to drive you somewhere. So these are all service contracts. And hence, you will notice, friends, a womb happens to be a human organ. Now, can you trade in human organ? Can there be a commercial contract in human organ? I think no, because that is also public policy. You can gift human organ, you can donate human organs, and that's why we say blood and kidney cannot be part of commercial contract and commercial trade. Now, if you notice the Surrogacy Act of 2021, it also says commercialization is not acceptable, right? So contract cannot be applied in that sense. However, in the Stearns versus Whitehead case, no such law in the United States existed precisely in terms of the fact that what about surrogacy, what about a womb? So renting of a womb they thought is possible. It is temporary. Renting means temporary, right? 9 months. And after that, you have to hand over the baby. But in the Stearns versus Whitehead case, what happened was, once the baby was born, the surrogate mother started feeding the baby and she got attached to the baby and hence she ran away with the baby. She refused to hand over the baby to the Stearns. And that is when the Stearns went to the court and they wanted the enforceability of the agreement, because under that agreement, Mrs. Whitehead had promised to hand over the baby to the Stearns. So the Stearns sought enforceability of the agreement. They sought specific performance. They said, look, Mrs. Whitehead had agreed to give the baby, that is specific performance. We don't want damages. See, damages is not going to be an equivalent remedy at all. What will you do with that money? The baby is yours. You want the baby to be looked after in your place. And hence from that, you will notice that the Stearns wanted only remedy, and that only remedy they wanted was that they wanted the child from Mrs. Whitehead, and Mrs. Whitehead had actually ran away with the child. Right? So did Mrs. Whitehead breach her contract in which she had agreed that, look, I would be handing over the child, that is my responsibility, for which I have already received consideration. And you will notice that I think to a larger extent, the court in this case did found Mrs. Whitehead in violation of her obligation. But at the same time, the court said, look, it's difficult to call this kind of contract as being enforceable contract because there is emotion attached. The surrogate mother is attached to the child both genetically as well as emotionally, right? And we cannot give Stearns the entire right of enforcing the contract. If that would have been, the Stearns would get the sole custody and exclusive right over the child. However, this was traditional surrogacy in which the Stearns and Mrs. Whitehead both had some genetic connection to the child, and hence there had to be a balancing of interest and balancing of rights. And you will notice that Mrs. Whitehead in this case was given visitation rights. She could visit the baby because she had rights over the baby. It was not like the modern surrogacy where surrogate mothers just provide the womb. So I think taking all those due note and consideration of, the courts in the United States had to evaluate whether that agreement is enforceable at law. But unfortunately, they did not hold it to be so. One can say fortunately as well. But what they did was, the major portion in this case, they said, let us not look at it from a contract or a commercial sense. What we have to look at it right now is the best interest of the child. In the baby Manji's case as well in India, the Supreme Court also looked at the best interest of the child. They were not bothered about the agreement. They were not bothered about visa. They were not bothered about what happened, who came. The grandmother did come over here. And can you hand over a child to a grandmother? You'll have to evaluate the physical, emotional, and psychological strength of the grandmother to take care of the child. But that was probably the best interest of the child, because the child could not remain in India or in an orphanage, or anyone else taking care of the child may not be a feasible option. So grandmother could exercise that best interest of child. She was able to convince the court, and the court handed over the baby to the grandmother in the Indian case. So surrogacy, friends, also posed challenges of public policy in general. And right now you will notice that while we rule out commercial aspects of surrogacy, it's an interesting dimension about how surrogacy started from a contract. It started from consent. And right now we refuse to hold it as a commercial contract because we think this is not something that the law and public policy would accept it as. So commercializing of surrogacy is prohibited. Once there is no commercializing of surrogacy, a contract of surrogacy is not a contract. It is now going to be governed under the law of 2021 in India, and that would be the basis of determination of rights between the parties in the contract as well.